Proceedings are resumed. Please be seated. Legal Services Bill 2020, continuing. Does any other member wish to speak? The member from Northside.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make my contribution to the Legal Services Bill 2020, now before this Parliament. Mr. Speaker, this bill is entitled "A Bill for a Law to Repeal and Replace the Legal Practitioners Law 2015 revision, to regulate the practice of the Cayman Islands law, to provide for a system of legal education, to provide for a mechanism to deal with professional misconduct for incidental and connected purposes." If the bill had stopped at the word misconduct, it probably would have my full support. But it's these incidental and connected purposes that give me concern. Mr. Speaker, I have always supported legislation that would provide a modern professional framework to govern the legal profession in the Cayman Islands. Economic and immigration carve-outs engineered so craftily by the architects of this bill that I do not support and will not support. Those items related to ownership and immigration belong in the trade and business law and in the immigration law through a tightening of our enforcement and the granting of work permits. But, Mr. Speaker, the battle royale is raging. The elite stratosphere of some lawyers who are the crafters, supporters, and promoters of this bill and its provisions are concerned only with the protection and maintenance of their economic engine that delivers billions to them every year. They have no concern about the regulation of the practice, the system of legal education, nor mechanisms to deal with professional misconduct. Those three items are but the Trojan horse that these stratosphere elitists of the legal profession in this country use to bring in their economic benefits. On the other hand, the young and not so young lawyers who live and work here on planet Earth below the elite stratosphere want us, and they promote a bill to regulate the practice of law, improve the system of legal education, to deal with professional misconduct. These Cayman lawyers want to develop and improve the legal profession. These Cayman young attorneys want to belong to a profession that is respected, well-disciplined, and its regulations are consistent, fair, and provides a level playing field and promotes equal opportunity for all who belong to the profession. The executive summary that was circulated with this bill, Mr. Speaker, says that the salient points of this legislation are, and I quote from the Legal Services Bill 2020 Executive Summary Introduction. The salient matters addressed in the bill are as follows: the establishment of the Cayman Islands Legal Service Board as a regulatory authority and to be assigned as the supervisory authority for the purposes of the Proceeds of Crime Law 2020 revision. B, the regulation of the practice of Cayman Islands law. C, the requirement of 5 years post-qualification for a person other than a Caymanian or the holder of a residency and employment rights certificate to be admitted as an attorney at law by virtue of a foreign qualification. D, the practice of Cayman Islands law in other jurisdictions. And E, access to the legal profession and training and development of Caymanian attorneys at law. Of those salient points, Mr. Speaker, the one that I do not support and agree with is D, the practice of Cayman Islands law in other jurisdictions. Now, Mr. Speaker, there are some changes that I would like to see made to the way Caymanians qualify as attorneys to be called to the bar. As I understand the process now, you can go to the Truman Borden Law School or any other university and get your Bachelor's of Law degree. I think it's a 3-year academic course, to be followed by an 18-month PPC, Professional Practice Certificate, and upon successful completion of the PPC, one has to find a law firm to be articled for 2 years, after which an attorney from the firm goes to the Grand Court and tells the presiding judge that the person can be called to the bar. But there is no obligation on that firm making that recommendation to give the Caymanian a job. Yet, they have persons on work permits with only 3 years PQE. So the Caymanians can never catch up to the experience level and the requirement. When I talk to the young Caymanian lawyers, they see this 3-year or 5-year, we're making it now, PQE, a little different from how we see it, or about how we've been made to believe that it helps Caymanians because it prevents the law firms from employing persons from overseas with less than 3 or 5 years PQE. Their argument is that when the post is advertised by the law firm, one of the requirement is 3 years PQE, or it'll now be 5 years PQE. And they, as young lawyers coming out of law school, having completed everything and being called to the bar, cannot qualify for the ad because they don't have the 3 years experience. And no law firms in the Cayman Islands are advertising for any lawyers with no experience. They believe that that is a matter for immigration and the granting of a work permit. And the overriding factor should be if there's any Caymanians who are qualified as attorneys called to the bar who need a job. So there's a two edges to that sword. Now, Mr. Speaker, as I said earlier, I support the aspects of this bill that deals with regulating the legal profession with some minor changes, which I'll get to later as I go through the clauses in the bill. However, I do not support the licensing of persons specifically to practice Cayman law in other jurisdictions. My disappointment in the elite stratosphere of the legal profession is that they refuse to separate the two and place priority, emphasis on the much needed improvements to regulating their own profession. Instead, they have consistently held up this legislation to enhance, improve the regulation, and raise the standards required for lawyers practicing in the Cayman Islands. They have and still place a higher emphasis and priority on the economic opportunities, the millions they make, even if it means breaking the current law, and specifically Section 10 of the current law. This is all about the money and more money. Every time in the last 5 or 6 years that I have been invited by these lawyers to discuss this bill, the conversation has started about money. How much millions they bring to the country, how much millions the industry concentrate. As recent as the last sitting of the LA, I was invited to meet with SILPA. When I got there, they had 4 items on the board they wanted to discuss with me. First one was money. Second one was regulating the profession. The third one was improvements to the qualification process and schooling for attorneys. And the fourth one was to do with some formula for immigration carve-outs, that they must have one lawyer in Cayman for everyone they have licensed overseas, or some other formula. I told him, stop. I'm not here to discuss 1 and 4. 1 and 4 is of no interest to me. I am here to discuss 2 and 3. How can we improve the legal profession, the regulation of legal profession? How can we improve and level the playing field for Caymanians to qualify to be attorneys in this country? And we started the conversation, but invariably they brought the conversation back to the importance of how much money this country gets by having Caymanians licensed to practice law in other jurisdictions. That is that level of the industry in Cayman, total focus. When you try to drill down in why is this, then they start to want to admit, quasi-admit, well, we've been doing this for a long time, it's really not legal, and we might get in trouble, and the country might get embarrassed, and what we need to do is find a way to really license these people so that we can have control over them, etc., etc., etc. That's what they want to talk about. They don't want to talk about how do we handle misconduct in the legal profession, how do we improve the legal profession by improving the legislation, and how do we assist and provide easier and a more direct route for Caymanians to get qualified as attorneys. It is almost refreshing, Mr. Speaker, to talk to younger attorneys, Cayman lawyers, before they get influenced by that money train, because they're the ones that are willing to talk about improving the profession, making it easier, how to better monitor through Mountbatten Law School, how to make it easier for people to qualify through an examination which is objective rather than a subjective evaluation by some attorney that they can't get along with, to go to the judge and says, this person has worked with me for 18 months or 2 years, whatever the requirement is, and they're now qualified to be an attorney. They want to change that system. They want to be able to do an exam at the end of the PPC course that qualifies them to be called to the bar and they are called to the bar on the success of that exam. One of their recommendations is, instead of having to do 18 months of articling after the PPC, is that you extend the PPC by 6 months. In the last 6 months, you have to work in attorney's office, but on a prescribed curriculum, such as you have to do X number of hours in contract law, X numbers of hours in trust law, X numbers of hours in customs law, and that, though you can get questions in your examination for the bar on that experience that you get out there, and Mr. Speaker, I'm not a lawyer, so I don't know what the qualifications and what the experience level should be. I think it's like any other profession. If you're just out of school, everybody knows that your experience level is low, and I think in the legal profession, it's like any other profession. Your billing level is related to the experience that you have. But you should be able, once you've passed your bar exam, to hang up your own shingle and not have to go and plead and beg and cajole some law firm to hire you for 18 months to move, as they tell me, files around the office with no real training and experience to get called to the bar. They are very, very concerned about this proposal to legalize practicing Cayman law overseas. The young Cayman lawyers see this and are concerned about the shrinking of the economic pie that they have worked so hard through school to try and become a part of. But most of all, Mr. Speaker, these young attorneys are concerned and disappointed that the senior members of the bar, as they call them, is not doing enough in this legislation to improve the requirement to enter the profession for Caymanians and the regulation of the profession after they get into it. As I said earlier, Mr. Speaker, I think that the ownership questions about how many partners should be Caymanian, what percentage of the business should be Caymanian, should be addressed in the trade and business law. They've been getting away with it for all of these years because they managed, when the trade and business license law was passed, to have an exemption built in to the law for lawyers and doctors not having to have a business license under the trade and business license law, which requires 60% Caymanian ownership. But again, it's very difficult to engage these senior people who are promoting this thing about licensing lawyers to practice overseas into any kind of academic or intellectual or serious discussion about these things. My position is simple. We need to amend the trade and business license law to remove the exemption from doctors and lawyers from the business license. They must have 60% Caymanian ownership, or they would have to apply for an LCCL. And you know, my position is on them. We should start granting them, period, LCCLs. So, Mr. Speaker, let me turn to the bill and make a few comments on some clauses on the bill. 4.1 of the bill, clause 4, which sets up the board. I believe that the board should consist of at least 7 members. I think the kind of authority, the kind of responsibility, the kind of work that we expect this board to perform needs more than 4 members. I don't think that 4 members is sufficiently representing of the breadth of the legal fraternity. Also, I like odd numbers to reduce the likelihood of a tie. The traditional members could be one could be a sole practitioner, could be lawyers with more than 10 or 15 years experience, preferably lawyers who have retired and no longer in the employ. But we're not too worried about that because I think we have magistrates and judges who sit on the bench now who also work while they're sitting as magistrates or Grand Court judges. But I'm not sure about that. And the law should clearly state that all members of the board should be Caymanian. I believe that there needs to be a definition in the law of sole practitioner in the law, because I believe there are some sole practitioners here that represent an important part of the legal fraternity, not necessarily in the financial industry, but certainly in advocacy before the court. The other clause in clause 5, which lays out the functions of the board, I think it now says to encourage and promote. I would like to change that to promote and ensure upholding of the rule of law. I don't see why the board should be encouraging people they need to ensure that they're following the law. It promotes high standards of professional conduct by attorneys at law. I agree with that. To regulate the practice of law in the islands. To encourage and promote the study of the law. Some of the young lawyers that I talk to would like to see a separate board created under the law to supervise the legal education and practical legal training to locally qualified for admission of an attorney at law. In other words, a board under this law that supervises the functions of the Truman Borden Law School and the whole idea of how you get your professional qualifications. We have in the bill the supervisory authorities defined in section 2.1 of the Proceeds of Crime Law, and I won't bother to read it. Everybody has copies of the law. 4.9, the Proceeds of Crime Law, and then we have the situation where a general commercial notice was issued in 2019 that note the proceeds of crime pursuant to section 4.9 of the Proceeds of Crime Law assigned to the Cayman Islands Legal Practitioners Association the responsibilities for monitoring compliance of attorneys at law and money laundering regulations made under the Proceeds of Crime Law. The young people that I talk to would prefer to have that under something other than what is currently set up. I think it's called CARA or something like that now. And it should either be a subcommittee of the board or an independent monitoring authority, which could also handle the money laundering aspect of it, such as SEMA or some other recognized authority. The law should require board members with a conflict of interest in a matter that is to be dealt with by the board, or where they're otherwise unable to act to recuse themselves. I think that clause 12.2 should be deleted. There is no requirement in the bill that I saw as to how often the board should meet. I think 15.1 should require the board to meet at least once a quarter. Quorum should be the majority of board members. clause 15.7 is this clause in the bill seems to contemplate the possibility that there may be members beyond the amount stated in the bill. Furthermore, the bill does not create a procedure for the appointment of a co-opted person, because if you go have extra people beyond the 4 people, they must be co-opted in some way. If somebody is going to be co-opted, it should be properly done and through an agreement by the board members, and it should be for that specific or particular purpose with which that person is co-opted for. Not just that they can go and just add members to the board for general purposes just to get whatever decision they want made. (24.5) is a little bit troubling to me, because this subsection seems to create a carve-out for those who practice Cayman Islands law without a practicing certificate. The subclause seems to go against the very reason that the bill was drafted, which is to regulate and hold accountable those who practice Cayman law in the islands and in foreign jurisdiction. And one of the things that these young Caymanian lawyers think is that the qualifications to license somebody, or the requirements for somebody to be called to the bar in Cayman to specifically to work in some other jurisdiction should be no different from what it is in Cayman, and you should have to do at least the 18 months working in Cayman. The Caymanian lawyers who are academically qualified by having their LLB and the PPC do before they can be called to the bar. It is hard for them to understand that being ordinarily resident in another jurisdiction, irrespective of your experience level, should just allow you to be called to the bar here, and you come in on one flight, get called to the bar, and because you have the 5 or 6 or 10 years experience, and you leave the next day to practice the Cayman law in another jurisdiction. Because they believe that the way that was originally started, where you had to have Caymanian experience to be seconded overseas from a Caymanian law firm, was a better way to do it. And they think that they believe that they're going to lose a certain control on the numbers unless you go build in some kind of a formative action in this, and they can only have a certain number. Well, we don't need a controller now. We need to stop them because it's illegal. Prosecute them before the courts. They know what they told me, that they believe what they're doing is illegal under Section 10 of the current law. But everybody's turning a blind eye. Right? I keep saying, Mr. Speaker, one of the things we should try to eliminate from evaluating what people's input out is looking for motive. Sometimes we should just listen to what the person is saying and evaluate it without looking for a motive. one of the things that jumps out is under 35.5, notwithstanding section 1 and 4, a failure to comply with subsection 4 does not amount to professional misconduct. But any such failure may in disciplinary proceedings be in relation to the attorney at law or a recognized law entity be relied upon as evidence to establish professional misconduct by the attorney at law or recognized law entity. How does failure to comply with section 4 not simply amount to professional misconduct? Why is that then have to go through some kind of process to additional process? I don't understand it. (45.7) If a law firm fails to comply with a requirement of this section, the law firm commits an offense and is liable in summary conviction of a fine of, I think it's $5,000. The numbers that they're talking about, I think that should be $100,000. I mean, I'm just going by the numbers that they show me, what their incomes are. I mean, not necessarily that the punishment should relate to income, but as we know, all of this is up to, so we can look after the small one, right? But when the big boys do it big, because they normally will do it bigger than the small one, right? And their sins will be bigger, they should have to be paid more than $5,000. That's kind of low. Even if you don't want to go all the way up to my suggestion of 100, I think there's room for increasing that penalty based on the severity of the action and whether it causes a black eye for the country or whatnot. I think the law proposes to change the process of getting called to the bar from submitting to the clerk, of course, to the board. And if the board is not specified how often it meets, how long does one have to wait to get registered if the board is not meeting? Or do we expect some executive employee of the board to register these people as being called to the bar? I don't think it's clear enough. Oh, but I know the old law. Oh, okay. Mr. Speaker, on part 9, I would like to see some more influence placed on local education and training, and somehow, as I recommended earlier, that we set up a board of governors for the law school, and how some of the representation of new graduates from the law school, maybe some students from the law school, some of the faculty, but some governing body of the law school that can regulate the whole education and look at this thing of combining some of the articling along with the PPC to shorten not only to shorten the qualification period, but to improve the qualification period and try to make sure that the people are, the evaluation of the person is more objective than it is subjective under the articling process. Same with 97.2. A person who contravenes subsection 1 commits an offense and is liable in summary conviction to a fine of, I think it's $10,000, or to imprisonment for a term of 5 years or both. I don't think that $10,000 is enough to discourage them from doing it. Again, I would like to see that moved up to about 25,000. And where an offense is committed by a partnership, limited partnership, or board or corporate, those entities should be fined at least a minimum of $100,000. And maybe the bill should identify where the details of practice and certificates will be published. Is this going to be in a record at the court that the clerk of courts, that somebody can go and examine it, or is there any plan to make it open to the public in some way? Okay. And I think I would like to see some kind of report from this board come to Parliament on an annual basis as to the numbers of people who've licensed, how many people are practicing overseas, et cetera, et cetera.
Member, we reached that hour.
5 minutes and I'm done. 5 minutes and I'm done.
Okay.
Mr. Speaker, those are some of the changes that I would like to see made to this bill. I'm very reluctant to support the bill in its present form. I also support many of the amendments that have been filed by the Leader of the Opposition. And I think if we can have a serious exchange and debate in committee stage to get some of these changes, I hope to find a way to support the bill. Thank you, Mr. Speaker.
Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption.
Question is that Standing Order 10-2 be suspended in order for the business of the House to continue after 4:30 p.m. All in favor? Those against?
No.
The ayes have it. House will continue its business. Does any other member wish to speak? The member for Bordentown West.
Mr. Speaker, I respond for what I say, and I respond for what you hear. Yeah, the break was so long, it gave me enough time to actually do a whole speech during that break. No, man, remember the limit is 2 hours, you know. Actually, can I start? Thank you. Mr. Speaker, the 3 primary ingredients needed in a bacon, egg, and cheese sandwich are bacon, egg, and cheese. And while we can all agree that those 3 ingredients blended together is what will give the sandwich its unique taste, all 3 ingredients are not created equal and do not arrive at the table equally. As the cow gives up the milk to make the cheese, the chicken gives up one of her eggs, but the pig gives up his life. Simply put, Mr. Speaker, the cow and the chicken continue with their lives while the pig gave up their life. Our job here, Mr. Speaker, is to make sure that the Caymanian people bring home the bacon, but don't become the bacon. Mr. Speaker, I rise to offer my contributions on the Legal Services Bill that is before this honorable House today. Before getting into my contribution, I want to also start off by thanking the many individuals that worked on this bill, both in the public sector and the private sector. Many of them have given up their time and resources for the bill to reach this far, and it is not my intention to be critical of their efforts, but rather recognize their efforts in trying to make the legal profession better. Mr. Speaker, I've often said that people know what they know, and they don't know what they don't know until they know. I say that to say that we can only see things through our own lenses that are based on our own experiences and circumstances. With that said, it is not my intention to question the motives of anyone who had input into this bill, whether from the private sector or the public sector. Everyone contributed their own ideas. Mr. Speaker, it is this collective ideas of many people that are reflected in the bill before this Parliament, and our job as legislators are to debate those ideas. Democracy, after all, is about competing ideas, and I hope that my contribution here today reflects that democratic principle. Mr. Speaker, maybe it is irony or providence that the first substantive bill being debated by this new Parliament is the Legal Services Bill. I have said many times that democracy is a system that requires us to debate and discuss differences, disagreement, discord, and dissent, and no bill thus far, for so long, have had many differences and disagreements over such a long period of time. Mr. Speaker, I am very aware that this bill is contentious, but nobody should be surprised. After all, the bill is dealing with lawyers and the provision of legal services in the Cayman Islands. Mr. Speaker, I also want to take the time out to recognize the efforts of the Honorable Attorney General and his team in progressing this issue in this Parliament, and every member thus far who have made their contributions. On the surface, this bill says that it will replace the legal practitioner's law, regulate the practice of Cayman Islands law, provide for a system of legal education, provide for a mechanism to deal with professional misconduct, and incidental and connected purposes. Mr. Speaker, my contributions, therefore, will focus on those areas, starting with the replacement of the legal practitioner's law. The legal practitioner's law that this bill will repeal was first enacted in 1969, several years before many of us in this Parliament was born. Since its enactment in 1969, the legal practitioner's law had 14 amendments, one in the 1970s, 5 in the 1980s, 2 in the 1990s, and 6 since 2000, with the last amendment taking place in 2012. Mr. Speaker, I am sure that we can all agree that the world is a completely different place since 1969, and that the Cayman Islands have come a long way since 1969. The 14 amendments made to the legal practitioner's law since 1969 tried to keep up with the ever-changing pace as we move from the islands that time forgot to a leading international financial center. Mr. Speaker, I am sure that we can all agree that it is time for us to have a modern law that reflects the world we are living in today, and one that reflects the position of the Cayman Islands in the world today. As I said earlier, we're no longer the islands that time forgot, but rather a leading international financial center and a major player of financial services on the global stage. Mr. Speaker, since we can all agree that there needs to be a new law, the next thing for us to agree on is how this should be done. I'll be the first to tell you that we should not let the perfect be the enemy of the good, and as such, no bill will ever be perfect. thus the reason why we have amendments. I now turn my attention, Mr. Speaker, to regulating the practice of Cayman Islands law. Mr. Speaker, the Oxford Dictionary defines regulation as an official rule made by a government or some other authority. What we're doing here today, debating a bill that deals with how the practice of law is regulated in the Cayman Islands. And Mr. Speaker, while the legal profession may be considered unique to us in this Parliament, it is just another profession, and as such, we need to have some level of consistency with our regulation. We cannot be seen to be treating one regulated profession different from another. Additionally, Mr. Speaker, because this regulation is being done as an act of Parliament, it is therefore important that some fundamentals within our democratic system of governance be reflected in this bill. To this end, Mr. Speaker, the Honourable Leader of the Opposition has filed 76 amendments to the draft bill that we in the official opposition believes will strengthen the bill and ensure consistency with the regulation of other professional services and greater consistency with the spirit of other laws such as the Public Authorities Law, the Public Management and Finance Law, and most importantly, in my opinion, compliance with Section 26(1) of the Cayman Islands Constitution. For ease of reference, Mr. Speaker, I raised that issue as I was also concerned, like the Leader of the Opposition, as to the impact that that bill or that section of the bill would have on the Constitution. And for ease of reference, Mr. Speaker, I just want to remind members and the listening public what it actually says. And it is Section 92(1), and it's the section that deals with appeal from decisions of the board. And it goes on to say, an attorney at law may appeal to the Court of Appeal against an action taken by the board under Section 84. And, Mr. Speaker, Section 26(1) of the Cayman Islands Constitution says, and this goes under the section, enforcement of rights and freedoms. Any person may apply to the Grand Court to claim that government has breached or threatened his or her rights and freedom under the Bill of Rights, and the Grand Court shall determine such an application fairly and within a reasonable time. Now, Mr. Speaker, I am open that either the Honourable Attorney General or the Honourable Premier, two members of the legal profession, can provide greater clarity on that issue and satisfy my concern. As I said before, it's something of my opinion. I am not a lawyer, but I just be curious as to that interpretation. Thank you. Mr. Speaker, I must also state that I have a fundamental objection to the position of Chief Justice being included on the board. I raised this issue in a meeting that some members of the official opposition are with the Honourable Premier and the Honourable Attorney General, and it is my understanding that this was a compromise position between most of the lawyers. And Mr. Speaker, while I can accept that compromise is a necessary component, I also recognize that the governance principles that form the foundation of our democracy cannot be compromised, and as such, I cannot support the inclusion of the position of Chief Justice in this process. And to some extent, maybe even the Attorney General, but we'll get into that a little bit deeper. Mr. Speaker, according to the 2009 Compendium of Statistics, there are 996 attorneys licensed to practice law in the Cayman Islands. And while I can probably live with the position of Attorney General being involved in this process, as I've seen it done elsewhere, there's nowhere else in the Commonwealth where I have found the position of Chief Justice being involved in such a process. And I ask the Honourable Premier and the Attorney General to provide an example of where the Chief Justice was involved in such a regulatory process. As a matter of fact, Mr. Speaker, I went as far back as to the Roman Empire, where the first lawyers were created almost 2,800 years ago. Roman law is considered the foundation of modern law, and it was because of the size of the Roman Empire why lawyers were created in the first place. Mr. Speaker, just last Friday, Mr. Speaker, we celebrated the full autonomy of this Parliament from the executive to comply with the separation of powers. We cannot now blur those lines by bringing the Chief Justice within the regulatory process, something that is usually reserved for the executive branch. Simply put, Mr. Speaker, we should endeavor our absolute best to ensure that the separation of powers is maintained, and I find it hard to believe that we cannot find one lawyer in almost 1,000 to replace the Chief Justice. Mr. Speaker, I want to use this opportunity to remind this Parliament.
Honorable member, sorry to cut or step in at this time. I didn't quite catch what you said about the Chief Justice being here at the August auspicious occasion of our Parliament opening.
Okay, I'll repeat that section.
Yes,
That's
I
fine.
didn't catch it.
That's fine. I said, I'll read back that section. It says, Mr. Speaker, just last Friday, we celebrated the full autonomy of this Parliament from the executive to comply with the separation of powers. We cannot now blur those lines by bringing the Chief Justice within the regulatory process, something that is usually reserved for the executive branch. Going back to the separation of powers, as I get further down, it'll be a little bit more clear to you.
I just want to make sure you wasn't saying anything about him being invited here.
No.
That's what I was.
No.
I'm sorry that you was a little bit blurred from my hearing there,
No.
because you know that is
Not
proper
protocol. Yeah.
protocol so to do. And if you're going to build institutions, we need the presence of the Chief Justice
And the
in
governor
such
and everybody
occasions.
was-
Definitely.
No one is
Okay.
arguing that. That's why I was referring to the regulatory process.
And then I caught the word where you say blurred. So
Yeah, that's
I think
fine.
I'm understanding what you're saying.
Okay, that's
thank
good.
you.
No problem, Mr. Speaker. Thank you. Mr. Speaker, I want to use this opportunity to remind this Parliament that the separation of powers were inspired by the Bible and can be found in Isaiah 33:22. For the Lord is our judge, the Lord is our lawgiver, the Lord is our king, it is he who will save us. The executive branch and the judicial branch do not mix. And while they can mingle as individuals, they cannot mix as office holders in our democracy. Mr. Speaker, our Constitution, the highest law in the land, does speak of the role and responsibility of both the Chief Justice and the Attorney General. For ease of reference, I want to remind the Parliament of their responsibilities. The Attorney General, Mr. Speaker, is covered under Section 56 of our Constitution, and it says, there shall be an Attorney General of the Cayman Islands, whose office shall be a public office, and who shall be appointed in accordance with Section 106. The Attorney General shall be the principal legal advisor to the government and the Legislative Assembly. And, Mr. Speaker, I'm just going to read Section 95:7 of the Constitution, and it says, the Chief Justice shall have the responsibility for and management of all matters arising in the judicial, and including responsibility, A, for representing the views of the judiciary to the government and the Legislative Assembly, including where appropriate through the Attorney General, B, for the maintenance of appropriate arrangement for the welfare, training, guidance of the judiciary within available resources. C, subject to paragraph D, for the maintenance of appropriate arrangement for the development of the judiciary and allocation of work within courts. And D, after consultation with the President of the Court of Appeal, who shall be responsible for the allocation of work within the Court of Appeal, for the maintenance of appropriate arrangements for the work of that court. Mr. Speaker, I want to make two final comments on this issue, especially with regards to the position of Attorney General in this regard. The Attorney General is a member of Cabinet. The Attorney General is a member of Parliament. And as far as I can check the last time, Mr. Speaker, members of Cabinet do not sit on regulatory boards. Members of Parliament do not sit on regulatory boards. And I know while in the past, before we used to appoint some MLAs, because I remember some MLAs being on some government boards, it is a practice that I understand that we have now stopped. And I don't think that we should be going back to the practice of putting members of parliament or members of cabinet involved in the regulatory process. So then, Mr. Speaker, I have to ask, why should we bastardize our democratic process to accommodate one profession because they can't get along with each other? And Mr. Speaker, while I understand that there may be instances where they have in the past, the practice needs to stop and not encourage. Because the Attorney General did give me an example before of something that was being done with regards, I think, to the MLAT and the judiciary, but that is something for a different time. The final comment on this issue, Mr. Speaker, is a result of what happened 5 years ago in December, when the Chief Justice was able to catch something that the executive branch missed. And I'm actually going to read from this news article, Mr. Speaker, so I'm going to ask the page to you can give a copy to the Premier and the Attorney General if they need one. Yeah. Okay, and it says, Mr. Speaker, the headline read, 5 foreign attorneys refuse admission in Ahab litigation. And it says, application highlights issues in legal practitioners' law. And while I won't be reading all of it, I'll be reading most of it. And it goes on, it starts by saying, 5 of 7 London-based solicitors and barristers were denied admission to practice law in the Cayman Islands for limited purposes following a ruling made by Chief Justice Anthony Smelly earlier this month. Justice Smelly denied the majority of the applications, citing Grand Court practice directions or rules that state limited admission or junior counsel will not be granted in Cayman except in unusual and special circumstances. This is for the well-recognized policy and practical reasons that the services of attorneys at law of equivalent experience will be readily available from amongst the local profession, Mr. Spelly's ruling on December 10th indicated. The admission of the additional non-Caymanian attorneys sought by local law firm HSM Chambers and his partner Hugh Moses, Bill Elfridge, and Ian Lambert emphasized the highly unusual and complex nature of the civil court case in which the firm is involved. The matter has been ongoing in one form or another in the Cayman Islands and other international courts since 2009 and is expected to go to trial in Cayman in mid-2016. The civil case alleges the misappropriation of more than US $5 billion by a defendant named in the case, Man Al-Sania, from the financial division of Ahmed Ahmad Al-Ghashabi and Brothers Co., also known as Ahab. I will skip the rest of the particulars of the case, Mr. Speaker, but I'm going to continue on the second page where it begins the part that says, according to the ruling, the 7 London-based attorneys were all granted work permits, allowing them to be present in the Cayman Islands to work on the case, but fees for their services can only be recovered as costs from the litigation if they are granted admission to the local attorneys bar. In other words, if the AWOL companies are successful in the litigation and manage to recover costs from the other parties, the attorneys could not be paid out of those costs unless they are granted admission to practice in the Cayman Islands. Although the London-based attorneys working on the case with HSM Chambers are charging less than Cayman-based attorneys would for the same work, Chief Justice Smelly stated there were equally significant policy concerns that needed to be addressed with this application for their admission to the local bar. These include the fact that many law firms and practitioners within the islands are usually quite able to provide the kind of professional services needed even for the most complex kinds of civil and commercial litigation, Mr. Smelly wrote. Their continued ability to do so would be significantly impaired if they are generally to compete with foreign lawyers as well. The routine granting of applications such as these would therefore be injurious to the interests of the local profession. And the last page goes on to read, Mr. Speaker, Section 4 of the Cayman Islands Legal Practitioners Law sets out the ways in which applications for limited admission of foreign lawyers can be made. But Justice Smelly said it must be construed and intended to protect the local profession from undue foreign competition. While the law and the Grand Court practice rules will, more liberally, allow requests for a senior overseas counsel, such as Queen's Counsel, a different view must be taken to a desire to bring in junior counsel and solicitors from overseas, Justice Smelly indicated. According to submissions of behalf of HSM Chambers, the admission applications were urgently needed to prepare for a trial set for July 2016. Mr. Moses argued that HSM Chambers is a small local firm and had no choice but to enlist overseas lawyers in order to properly represent their clients in this complex and difficult case. Justice Smelly states that the HSM litigation team in this matter, led by Messrs. Elfrich and Lambert, may have been made up of at least a dozen lawyers, only 2 of which, the partners, were based in Cayman. Most of the work, the Chief Justice stated, appears to have been done in London. Mr. Moses stated that at this stage of the case, a number of other leading Caymanian law firms are involved in the matter, and it would likely not have been possible to find anyone who is not conflicted. Mr. Moses also indicated that his firm would not have recruited new attorneys for this single case, not knowing whether they could keep them on following its completion. The Chief Justice did not accept this argument. Other firms in Cayman have recruited for a bit litigation, and in some instances for this very case as well. In conclusion, the application of 2 of the 7 overseas lawyers was accepted by the court, which left it up to the employer to determine which two will come to work in Cayman for the remainder of the litigation.
Member, are you asking for the paper to be laid?
Not really. No, not really. It's in the public domain. In short, Mr. Speaker, the reason that I jumped on my radar, and I remember it from back then, was the Work Permit Board had granted the permits, but I can tell you that usually when the Work Permit Board grants a permit, it will usually be subject to approval, I think, like pretty much from the Chief Justice or something else. But the thing about it is, Mr. Speaker, is that the Work Permit Board didn't, and I don't want to use the word, I don't want to be critical, but it goes to show why it's important to have certain level of expertise on some of these government boards, especially when it comes on to the legal profession and other professional qualifications. Because I doubt that members on that board would have been able to catch something like this. But nonetheless, it is part of the whole process where something was missed on one board, but the Chief Justice, being separate, was actually able to catch it. And the point I'm trying to make here is that you kind of almost want to keep that 2-tier system of catches where if one misses it, another one kind of catch it, as opposed to where everything just goes through just one as it stands. But we'll get into that a little bit deeper. But the bottom line is it's still a check and balance within our system. And to some extent, we need to find the best way in which to maintain that system. And that is why the Honorable Leader of the Opposition filed an amendment changing the board to an authority, and that is why I support such an amendment, as it would be consistent with other regulatory bodies such as SEMA and OFREG and other statutory authorities and government-owned companies. Mr. Speaker, every member in this Parliament knows the value of the financial services industry to our islands. And if there were any doubts, this global pandemic further highlights the importance of the financial services industry when considering the current challenges in the tourism industry. Mr. Speaker, in normal times, pre-COVID-19, the financial service industry drives more than 60% of our GDP, but employs around 10% of our working population. Using information from the 2019 Compendium of Statistics, as prepared by the Economics and Statistics Office, between 2011 and 2019, the number of persons employed in the Cayman Islands increased by over 12,000, going from just over 35,000 employees to over 47,000 employees. Equally, Mr. Speaker, the number of persons employed in the financial services industry has remained relatively flat, going from 3,005 in 2011 to 3,502 at the end of 2019. I want to bring to this Parliament's attention that while the number of employees in the financial service industry dropped to 3,502 at the end of 2019, just a year earlier, in 2018, the number of employees was actually 4,425. In short, Mr. Speaker, between 2018 and 2019, there was a decline of 923 jobs between 2008 and 2009, between 2018 and 2019 in the financial services industry. But, Mr. Speaker, while there was a decrease of 923 jobs in financial services between 2018 and 2019, you'd be surprised to know that during the same period that the number of attorneys licensed to provide legal services in the Cayman Islands increased by over 200, going from 794 attorneys in 2018 to 996 at the end of 2019. Simply put, Mr. Speaker, while the number of jobs in the financial services industry decreased by over 900 between 2018 and 2019, the number of attorneys actually increased by over 200. In essence, Mr. Speaker, the legal services industry continues to be a growth industry and remains an area for us to direct future opportunities for Caymanians. Mr. Speaker, I also want to use this opportunity to highlight two other points. At the end of 2019, of the 47,000 plus people employed in our islands, 49% were female and 42% were Caymanian. However, Mr. Speaker, within the financial services industry, 57% were female and 68% were Caymanian. In short, Mr. Speaker, of the 20 categories of occupations that are measured in this country by the Economics and Statistics Office, only 4 have a higher female participation rate when compared to males, the other 3 being education, health, and domestics. Mr. Speaker, I wanted to raise this issue for a particular reason. A few years ago, I had a discussion with one of our prominent lawyers, Tony Travers, and surprisingly enough, it was over the provision and regulation of legal services. During my discussion, I asked Mr. Travers a question, and his answer surprised me so much so that I have to mention it here today. I asked him, what was the real reason for the success of our financial services industry? And while I expected him to have mentioned a particular piece of legislation, his answer actually surprised me. He said, Chris, the reason for our success was our Caymanian women. He said that when the businesses were leaving the Bahamas, the lawyers had 15 minutes in which to make the case for business to come to the Cayman Islands. He said that they told the clients that the expertise and infrastructure were here, when in fact it wasn't quite all here. But luckily for the Cayman Islands, we had women that stepped up to the plate and delivered. Mr. Travers said that he would leave them in the office at extremely late hours and would come back early in the morning and find them there. How they managed to get the work done, raise their children, and be back in the office in the morning was nothing short of amazing. My mother, my aunts, and many other women transitioned from being waitresses at hotels to administrative positions in the financial services industry. I say all of this to say, Mr. Speaker, that the financial services industry has been good to our women, good to our mothers, and what is good for the mothers is good for our islands. The opportunities available to many Caymanians in the financial services industry and the improved quality of life for many Caymanians' families proved that one of the successes of the Cayman Islands wasn't income inequality, but rather income ability, the ability to improve economic status. It is that income ability that was available to my mother's generation that we need to preserve and protect for this generation and the next generation. Mr. Speaker, in his contribution in moving this bill, the premier reminder this Parliament of my hunt and gather description of the financial services industry. Simply put, Mr. Speaker, of the 3,502 positions, less than 5% are real hunters, the people who generate business locally. Don't believe for 1 minute, Mr. Speaker, that around 175 people are responsible for driving more than 60% of our GDP, or around $2.7 billion of economic activity. A lot of that hunting takes place overseas, Mr. Speaker, and this is why it is important for us to get this bill right. This bill is not about our economic survival. This bill is about our economic existence. The global pandemic has highlighted the importance of the financial services industry, and that is why we must protect it. And Mr. Speaker, I can't help making this point. For decades, we have been told that we need to review our government. For decades, we have been told we need to review how our government generates income. Our model of indirect taxation has been attacked by many countries with direct taxation. Now look at the performance of their economies versus the performance of our economy. Mr. Speaker, back in the 1990s, when I received my scholarship, it was a time when graduates were expected to return and work in the public service. So I knew from an early age that I would have been in public service. When I returned home, there wasn't a job readily available, and I was told to find a job in the private sector until they found something for me. I decided to use that opportunity to increase my knowledge of our country works, with the view that when I return to the public service, that I've been able to add value. Long story short, Mr. Speaker, the powers that be in the public service hasn't found something for me yet, but as you can see from my membership in this Parliament, I'm able to fulfill my public service requirement. During that time, I've had the opportunity to gain the necessary experience to say what I'm about to say. My last full-time job prior to being elected was the Chief Financial Officer of a law firm. That job gave me the necessary experience to say to this Honorable House that the bulk of legal work isn't generated locally, but overseas. Mr. Speaker, do members of this Honorable House understand that this business isn't generated by placing ads in newspapers, magazine, or TV? When was the last time we ever saw the work that is being done by our financial services industry advertised anywhere? The work is done by personal business relationships that are built after years of networking. Who went to school with who know who, key business introducers, etc. And Mr. Speaker, if anyone doesn't understand what I'm saying, you need to look no further than the government's own revenues related to the financial services industry. More than half of the roughly $800 million collected come from financial services and work permits. Simply put, Mr. Speaker, the fact that such a large amount of government revenues are generated from financial services means that we in the local market don't have to find it. Mr. Speaker, I can tell you right now that our presence in those international markets are a requirement for our continued success in the financial services industry, and I support their presence over there. This is the world we're living in today, and while we may not like it or globalization, we still have to find our way to adapt and do what is in the best interest of our islands and our people. And, Mr. Speaker, what I'm about to say may be a little bit controversial, but it also needs to be said when considering Brexit and the rise of nationalism in Europe. Just as how we in this Honorable House are trying to protect jobs here for our people, why do we think that other politicians in other countries don't want the same for their people? You think that they want jobs for their people being taken by Caymanian lawyers? I say that to say, Mr. Speaker, that for us to be successful, we must work in partnership with other firms around the globe, as we achieve much more through cooperation as opposed to competition. And this bill must reflect that partnership that the industry needs to ensure that the business continues to flow to the Cayman Islands. Mr. Speaker, over the last 10 years, between 2009 and 2019, the financial services industry has seen an increase in new company registration. Ordinary resident companies increased from 487 to 738, an increase of 251 or 52%. Exempt companies increased from 6,764 to 10,448, an increase of 3,684 or 54%. Foreign companies increased from 392 to 694, an increase of 302 or 77%. Mr. Speaker, between 2010 and 2019, the number of mutual funds increased from 9,438 to 10,857, an increase of 1,419 or 15%. Number of stock listings increased from 1,113 to 2,078, an increase of 965 or 87%. And finally, Mr. Speaker, between 2010 and 2019, the number of attorneys licensed to practice in the Cayman Islands increased from 541 to 996, an increase of 455 or 84%. It is clear, Mr. Speaker, that the growth in the financial services industry also reflects the growth in the legal services industry. However, Mr. Speaker, what is missing from this analysis is the number of lawyers who are hunters that we have overseas generating businesses for our islands, and that is why I want to see them licensed and properly regulated. But, Mr. Speaker, I want to add that this is in no means a blank check to hire and register all overseas lawyers. I think it is important that we borrow a page out of BVI's book and require that all of them to obtain a temporary work permit before being called to the bar and licensed. I think this is particularly important as it would give new lawyers and existing lawyers an opportunity to see what is available and seek new opportunities. Additionally, Mr. Speaker, while I know that this bill is more designed for lawyers in the corporate space, which is the bulk of the legal service industry, I must ask that Parliament to consider the lawyers on the criminal side. The requirements of 5 years qualification may challenge the smaller firms that specialize in criminal law, and if they're also required to meet the 5 years requirement when there aren't many Caymanians going into criminal law, this means that they will have to hire lawyers that cost more, and this may drive up the cost in the local market, as well as put a strain on the legal aid budget. Remember, Mr. Speaker, those firms are owned and operated by Caymanian lawyers, and we also have responsibility to do what is in their best interest also. I therefore ask that the government to consider those in criminal law when looking at that requirement. The other reason I want the work permit process involved in this process is that I'm uncomfortable, or rather uneasy, with the board or commission getting involved in this process. We already have an area of government tasked with looking out for Caymanians, and they need to do their jobs. The inclusion of that section in this bill is proof that they have not done their jobs properly, and we should fix that process as opposed to trying to find another board to do it. Mr. Speaker, Mr. Speaker, we have all heard stories of Caymanians being unable to gain articles by some of those firms. As you are aware, Mr. Speaker, more than 10 years ago, your cabinet appointed me to the Business Staff and Plan Board, and as such, I was able to gain valuable insight into this issue. But, Mr. Speaker, the main issue that I would like to see the government do, that I believe will really help more Caymanians get into the legal system, is to bring back the A-levels in government schools. Mr. Speaker, as you're aware, there are more Caymanians studying in the UK today than there was before, and I believe that we should encourage more Caymanians to do so, as it is less expensive than in the United States. And although I myself was educated in the United States, I told my son point blank, when he was looking at universities, that he can go to any university anywhere in the world, as long as it was in the UK. The lawyers we have today are the lawyers we have today. And as such, my focus is more on those today that want to be lawyers tomorrow, regardless of their age. I am happy that my colleague from Newlands, the Deputy Leader of the Opposition, decided to pursue legal studies that will assist him in becoming a better legislator, and his commitment at this age and stage of his life shows that education is indeed a lifelong learning experience, and as such, we must keep the door open for legal opportunities for all Caymanians, regardless of their age. Mr. Speaker. Okay, yeah, well, the member from Newlands have made it perfectly clear he intends to stay here, so he won't be practicing. Mr. Speaker, I want to turn my attention to the issue of professional misconduct. Mr. Speaker, I'm sure that you, like me, and other members in this House, have heard the stories of lawyers behaving badly. And Mr. Speaker, as tempted as I am to use my parliamentary privilege to name and shame some of them and share some of the horror stories that members of the public have shared with me, I will pass. As my late father always reminded me that discretion is a better part of valor. Simply put, Mr. Speaker, not because we can, means that we should. I once shared some of the stories with the Honorable Attorney General and asked him what can be done about some of those lawyers, and he reminded me why we need a more modern legal services legislation. I hope that this bill will serve as a deterrent to some of them, especially those that specialize in repossessing people's homes. Mr. Speaker, some of the legal fees taken from the final amount of people that lose their homes are criminal, and I hope that this new board or new commission will tackle this issue as one of their first priorities. Mr. Speaker, as I said before, we cannot let the perfect be the enemy of the good. This bill is not perfect, but it is an improvement on what is there now. We recognize the value and contribution that members of the legal profession have made in the development of our financial service industry and our islands over the last half-century, and this generation and future generations will be indebted to them. We recognize that this bill also was done after discussions and consultations with many Caymanians in the legal profession, and we in the official opposition are appreciative of their efforts. They should all be commended. The government started the process by bringing this bill to Parliament. We in the official opposition did our job by reviewing the bill, discussing the bill with members of the public, and filing the amendments that we believe will strengthen the bill. I can say that I'm really hoping that we can come to some agreement that will, one second. One second, Mr. Speaker. I really can't read this, you know. Mr. Speaker, I can't make this out. No, see what I'm talking about. Yeah, no glasses. I need glasses for distance.
As long as you don't understand it and you can laugh, you can continue.
The government started this process by bringing this bill to Parliament. We in the official opposition did our job by reviewing the bill, discussing the bill with members of the public, and filing amendments that we believe will strengthen the bill. I can say that I'm really hoping that we can come to some agreement that will not make this bill an election issue, as the last thing we need is uncertainty in the legal profession and the financial services industry. Mr. Speaker, it is my intention to vote for this bill and to advance it to the committee stage so that we can hopefully find some consensus. But make no mistake, Mr. Speaker, myself or my colleagues in official opposition have no intention of the Cayman Islands being placed at risk. And Mr. Speaker, I just want to, in closing, just really say again, thanks to the Attorney General and his team, and those in Silpa and Alpa who also took the time out to try to explain this bill. As I said before, we're dealing with lawyers. It's very hard for them to agree on anything. It is one of the most contentious adversarial positions that we have, professions that we have. So this was never going to be something straightforward and easy as what the accountants have, because everybody want what the accountants have, but as you can see, we just live better with each other, and we get along much better. But the lawyers now is a different story, and that's just their adversarial nature. Mm-hmm. But Mr. Speaker, the most important thing that I want for us is to be able to get some agreement at the committee stage. We may not get everything, but at least some principles need to remain. As I said before, neither the Chief Justice, I have an issue with him being on that board. I understand he probably have an issue with himself being on that board. And as I said, even with the Attorney General, as a member of Cabinet and a member of this Parliament, sitting on that kind of board, I think it goes against the grain of what we have, because we don't put ministers and we don't put Cabinet members on those kind of boards anymore. That's a practice that we have done away with. And like I said, this is our financial services industry. This is not about economic survival. This is about economic existence. We're dealing with the people who bring business to our country, and it's important for us to get this right. It may not be perfect, but we at least need to make it better than what it is today. When you look at the first legal practitioner's law in 1969, I think there are about 5 different definitions you have. When you look at this bill today, it's probably about maybe 20-something or 30-something definitions alone before you get inside the bill. You know, and the issue also of the affiliates is one of the things that we have also raised, which we think that is also an issue of risk that needs to be looked at. Personally, I think it should all be done away with, because we need to make sure that we have a system in place to hold people accountable that we can properly regulate. But like I said, I'm going to vote for this bill to move to the committee stage with hope that we can find some consensus or compromise. But at the end of the day, the most overriding decision for me in this process is to make sure once again that our people can bring home the bacon and not become the bacon. Thank you, Mr. Speaker.
Does any other member wish to speak? The Parliamentary Secretary, Georgetown South.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make a brief contribution in support of the Legal Services Bill 2020. Mr. Speaker, the Cayman Islands Legal Services is a leading driver of our economy. It is one of Cayman's single largest financial services exports. In a highly regulated global economy, the Cayman Islands legal services must be regulated in order to retain the confidence of Cayman's clients and protect users of Cayman legal services here at home and abroad. So this bill is principally about protecting and enhancing our economy by ensuring that our legal services is effectively regulated. Mr. Speaker, effective regulation is a hallmark of leading financial centers. With significant wealth at stake, Cayman's clients require a level of regulation in line with international standards. Cayman currently falls short of the required international standard due to our previous failures to pass a bill to regulate attorneys' professional conduct, provide an effective disciplinary framework, and ensure compliance with global anti-money laundering standards. Unless this bill is passed, we risk damaging Cayman's brand and reputation and eroding client confidence in our jurisdiction. This would result in economic damage to our economy. Mr. Speaker, passing the Legal Services Bill is the means by which we prevent this economic damage. This bill would create a new regulatory framework through the adoption of a mandatory code of conduct, a disciplinary regime, and effective anti-money laundering supervision of attorneys. It would also bring all attorneys practicing Cayman law, whether at home or abroad, within scope of the Code of Conduct and disciplinary regime. Mr. Speaker, this bill is also about ensuring that we provide new opportunities for Caymanians to develop and progress their careers within law firms. To that end, we have for the first time the Professional Development Regulations. These regulations provide a structured career development and progression framework for Caymanian attorneys, ensuring that the development and progression of Caymanian attorneys is a central responsibility of law firms. It achieves this by providing for a comprehensive mandatory training regime and setting out new requirements for law firms to provide scholarships, training opportunities, articles of clerkship, mentorship, business development opportunities, overseas experience, and promotion opportunities for Caymanian attorneys. The passing of this bill would transform the legal services environment for Caymanians in these areas and create new opportunities for Caymanian attorneys to develop and progress within law firms. It also holds law firms accountable by requiring the filing of an annual compliance certificate confirming their compliance with the requirements of the bill and related regulations. Mr. Speaker, it is time now that we move forward to resolve this long-standing failure to regulate before it is too late, and ensure that we take these steps to provide new opportunities for our Caymanian attorneys to develop and progress their careers within law firms. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? The Honorable Minister of Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make a brief contribution to this legal services bill in front of Parliament today. And the reason that I say brief, Mr. Speaker, is because a lot has been said about the purpose of the bill, the provisions of the bill, the effect of the bill, and they have been, I believe, duly and ably covered in the introduction to this bill as presented by the Premier, but also as covered by many other speakers thus far. So I won't necessarily repeat a lot that has been said, but I'd like to use this opportunity, Mr. Speaker, to just reiterate again what I think is the main purpose of the bill as reflected in the bill, and basically expound my brief comments on focusing on a few of those, or the main purpose, as I said. So to reiterate the purpose of the bill, it is to regulate the practice of Cayman Islands law, first and foremost. And in doing so, Mr. Speaker, it would create an opportunity to determine who is fit and proper to carry out the practice of Cayman Islands law. Mr. Speaker, it also provides for a system of legal education, and it provides for a mechanism to deal with professional misconduct. Now, Mr. Speaker, as has been indicated, and even just having had the experience of attempting to bring this piece of legislation or a similar piece of legislation to this Honourable House during the last administration, it is clear that not only have we moved on as a parliament, but also as a country in recognizing that continuing with the status quo of what we have now is simply not acceptable. And I say that to say that in listening to the debate thus far, it is clear that we are all concerned about the fact that we have a piece of legislation that is governing a critical aspect of our economy, that is a practice of law, which ties very, very closely to a key pillar of our economy being the financial services industry. But, Mr. Speaker, as this bill rightfully requires or attempts to regulate the practice of law, which goes beyond purely that of financial services, it is rightly seen in its purpose as being to regulate the practice of law generally, irrespective of what particular industry or focus within that practice, be it commercial, criminal, civil, family, etc. But, Mr. Speaker, as has been discussed by a number of speakers, and I want to highlight and to thank the member from the Parliamentary Secretary from Prospect in his discussion, in particular with respect to the provision related to foreign qualified recruitment or recruitment of foreign qualified attorneys to the minimum of 5 years PQE. As we also heard from several contributions to this House, this is certainly an area that we will have to look at as a country, and the Council will have to look at closely into the future, because there are certainly pros and cons to codifying a higher PQE level versus a lower PQE level as it relates to the foreign qualified recruitment for non-Caymanians in particular. And to say that this restriction does not apply as the law, as the bill expressly says, it does not apply as it relates to Caymanian and married persons married to Caymanian, because again, it is a way to ensure that Caymanians and those closely connected to the country are given the first opportunities to get those junior level positions, which are so absolutely critical, Mr. Speaker, getting that foundation as a junior lawyer and moving to be able to then move up the ranks. It's an important aspect of getting your foot in the door. And in many respects, Mr. Speaker, although we heard concerns about law firms generally not hiring per se to that junior position, because in practice the way it works is that many firms would take on the relevant articling clerks with the then intention to move those individuals that perform well at the articling phase to the next step. Mr. Speaker, so from a policy perspective, the reason that the 5 years PQE, as I said, in addition to the representations that the government got during the last time, and certainly a lot of it was reiterated by some quarters this time around, about the need to make sure that Caymanian attorneys are given those opportunities to not just get the articles, but to transition from article to junior associate in order to continue their progression within the profession. This allows the Caymanian attorneys, as I said, to be able to take on those junior roles, which in many respects, the law firm environment is a business like any other. Like any other business for profit, they want to maximize their revenue, but also their profits. And in many respects, the junior attorney is given a lot of the and I hate to use this term, but it's the reality, it's the way the profession is. It's given the grunt work to be able to carry out the wheels, the engines of the practice, because they are at that stage where they're still in learning the profession. So it does create an economic incentive to have persons who are reliable, who are committed and who are motivated. And in that respect, it also now, by limiting the scope of being able to recruit to that junior level, it does allow opportunities for Caymanians who demonstrate that level of commitment, that level of interest, that level of ability to continue to want to stay within the practice of law. It gives them greater opportunities now, because firms are having to now consider looking for those individuals and cultivating and nurturing the talents from within. And Mr. Speaker, again, I think it's important for people, and when we talk about creating opportunities for Caymanians within the legal profession, this government is certainly committed to that policy perspective, and that's why this was some of the considerations about why we felt the 5-year PQE was what we were going to put forward in this bill. But as has been discussed before, there are pros and cons to any such decision or position taken in this respect. But the biggest part, I think, about helping Caymanians to progress in this profession when it comes to opening the door, like we have done by putting forward this requisite PQE level before you can look outside of the jurisdiction to recruit, is one such mechanism. The more important mechanism, Mr. Speaker, for any junior lawyer, whether you are local, whether you are overseas, any person entering the profession of law, especially if you are entering in the corporate or the financial services related aspect of law, where there are the significant cross-border transactions, and you're acting in a transactional law capacity, it is a very competitive environment, and it requires extensive commitment and long hours. And I think, Mr. Speaker, in many respects, that first 3 to 5 years is when individuals get the opportunity, they realize, and they cut their teeth, but they also understand and appreciate what it means to really succeed in the profession. And as I've said on many instances, Mr. Speaker, and I guess I have a unique perspective in this to be able to offer. The firms, as we know, and as we've heard, local firms in this space do very well. But people work very hard as well. And we need to encourage that sense of understanding and appreciating and going into the profession with your eyes wide open as to what is expected. Mr. Speaker, I'll give an anecdote of the experience that I had when I joined one of the leading global law firms in London, where, again, as a junior associate, and just seeing how that firm was structured and how that firm was organized, where basically you had your on-site cafeteria, you had your on-site dental, you had your on-site doctors, you had an on-site gym, you even had on-site sleeping pods that could be reserved by associates as needed. And Mr. Speaker, I was, quite frankly, the first week I was quite amazed, because I couldn't figure out, in a city such as London, that was one of the most vibrant cities in the world, why would they need to have all of those facilities right there on premise? But Mr. Speaker, it didn't take me very long to quickly figure out why major firms in that respect invest and make that kind of investment as a part of their operations. And that is because it is all about helping to provide convenience in order to maximize productivity. And that, in this profession, is very much about the billable hours, how much you actually work, and how much of that you can actually bill to your clients. And so by minimizing a lot of time to be wasted to move back and forth to do various activities that would need and may come up in the course of the day, that is essentially the ethos. And I can't tell you how many, because I can't truly recall the number of times that I needed to pull consecutive all-nighters just to get the deal done in time to meet the client's expectation, because otherwise it could cost the client millions of dollars. And that, Mr. Speaker, I have to say, is coming from a firm that was often given many rewards for human resources awards, that is, for being some of the, one of the best law firms to work for in terms of work-life balance. So it's just to say that, especially at that stage in your legal career, it is absolutely critical for us to create those opportunities for young lawyers to get the kind of experience that they need to get within the domestic framework, but also I think the disadvantage that often Caymanian attorneys in particular find themselves when they're being measured against their overseas counterparts is not necessarily having that perspective that having the overseas experiences bring. I mean, that's a fact, Mr. Speaker. That is how it operates. That is how, when you're measured with respect to what you bring to the table. So, Mr. Speaker, by allowing the ability for local firms and the practice of Cayman Islands law to actually happen overseas, and I'll speak to that in a little bit, also creates those opportunities for our local attorneys to get that experience in those overseas offices to broaden their own their own knowledge base and their own experiences, to make those connections, to make those relationships, to get the kind of client interaction that they may not necessarily get just by remaining in the home or domestic office. So the ability of Caymanian attorneys to really advance in this area is very much dependent on being given the opportunity to do so, which is something that this government is really concerned about and looking to find ways to create those opportunities, but it's also very much dependent on the drive and the determination of the attorneys, the junior attorneys in particular, to take advantage of those opportunities by seeking out the ability to get those secondments or other type of exposures that may be available within the network of their own firms. So, Mr. Speaker, as I said, this government believes, and I wholeheartedly support the need for Caymanian attorneys to get the first opportunity, especially in those early years, to get the experience, to develop the skills and discipline necessary to succeed as a successful lawyer and to prove themselves and, let's face it, prove their financial worth to the firms at which they work. And again, Mr. Speaker, I believe that by not accepting the reality of the situation that is, which is the practice of Cayman Islands law, and there's arguments about whether that is permissible or not under this particular construct of our legislation, it is happening. And to say that we should not move this bill forward because of that situation puts us no further ahead to addressing the problem that may be seen or put forward by some people in that frame. Mr. Speaker, the fact is we need to get back to what is the primary purpose of this bill, and that is to regulate the practice of Cayman Islands law. Now, the fact that this bill allows for what is currently taking place, and as we have heard, is often a driver of the economic engine that happens locally. Not to mention just, we were talking about the frame of lawyers in particular, but Mr. Speaker, we haven't even talked and discussed about the auxiliary services provided in the domestic economy as it relates to jobs for corporate service providers, directors, administrators, trustees, all of these, insurance managers, all of these other, and accountants, all of these other services that are provided by the initial relationship that is built with the attorneys who advise on Cayman Islands law and setting up Cayman Islands law structures. All of that benefits the local economy and local employment. And as we have heard, and as I can certainly attest to firsthand, having the experience that I've had by practicing overseas, a lot of that is significantly enhanced and supported by the overseas offices. Because, Mr. Speaker, the reason I talked about and I gave the illustration of what life can be like at times, the multiple all-nighters, if we did not have as a jurisdiction the ability to interact with Cayman attorneys 24/7, because some of these deals are so complex, that are on extreme time constraints, that involve multiple jurisdictions. You need to be different time zones. You need to be able to interact with your local council, that being Cayman Islands Council for these structures, in real time. And if we did not have that opportunity, we would likely not get many of those deals that we currently get, the joint ventures, the funds, the deals that are either time sensitive, that require jurisdictions such as the Cayman Islands, that provide that neutral platform that's underpinned by the rule of law, the English common law base, all of the things that make the Cayman Islands attractive. There are many other jurisdictions that many other of our competitors in particular, that offer similar draws. So if the Cayman Islands was not operating in this space, we would be at a distinct disadvantage, because in this industry, more so than any that I think I can speak to, time is money. And you need to be able to be responsive, and you need to be able to have that real-time connection. And if we didn't have those opportunities, dare I say, people here, if the work did come in the volume that it does come now, would literally not have any life. And as I said, I've lived that domain for quite some time, and that is certainly not what I would wish for everybody in the legal profession to have to experience 24/7, 7 days a week, in order to make a living and a career in this space. So, Mr. Speaker, there are some practical considerations that having that ability to support the domestic economy and to support the jobs that are created as a result of the practice of Cayman Islands law locally, but also overseas, to help feed that business back to the jurisdiction. And as I said, not just within the classic lawyer space, but all of the other support services that are created as a result of that business coming to the jurisdiction. It is something that we need to be very cognizant of when we're talking about, potentially shutting down that door that is already open, that we've already been operating in for a number of years, and a door that is open with respect to our competitor jurisdictions, who would absolutely wait with bated breath to see that we make that move so they could swoop in to take that business. And we need to be very cognizant of the competitive nature of this particular industry. As I said, Cayman has an amazing products to offer. We continue to be innovative. The member from Bordentown West talked about, in very concrete terms, about the successes of our financial services industry as it relates to the support and really the work done by attorneys in ensuring that we have the registrations of companies, of funds, of the insurance management space. All of that is facilitated by the practice of Cayman Islands law. So we know the tangible benefits, and even more so now than ever as it relates to COVID and the experience of surviving and thriving, dare I say thriving during this pandemic from a financial services perspective. And I hope to be able to speak a bit more to that in a statement next week. But, Mr. Speaker, again, getting and reinforcing the primary purpose of this bill, that being to regulate the practice of Cayman Islands law, and in doing so, determining who is fit and proper to carry out the practice of Cayman Islands law. Mr. Speaker, it is incumbent upon me to express a sentiment that I feel very strongly about, as I expressed in 2017 when we debated the previous bill. I still feel very strongly about this because, again, I can speak from a unique perspective and experience of being called in multiple jurisdictions. I believe, Mr. Speaker, that as we've heard, this bill is definitely a step forward. We cannot afford to do nothing. We cannot afford to do what has been happening for the past 20 years, to say we don't have the perfect law, so we need to throw our hands up in the air, and then the status quo continues, and the abuses that have been highlighted, etc., will continue without any sort of recourse because we have no legal basis to take. So we know that we need to do something, but I believe, and I strongly believe, that at some point we will need to ensure that as a part of this regulating the practice of Cayman Islands law, that, and even being called to the bar to begin with, that the ability to demonstrate competency in Cayman Islands law, either by way of an examination, such as a bar examination, which is required to be when you're called to Canadian bar or the Ontario bar, or when you're called to the New York bar, or if you're called to in the United Kingdom, added to the role of solicitors, that being the form of a qualified legal transfer test, if for those people attaining, foreign legal education and training. So, Mr. Speaker, as I said, and I'm sure there are numerous other bars that have similar requirements, but those are the three that I'm more familiar with. And, Mr. Speaker, I was surprised that being called to the bar in Cayman, this was the only bar, even though, again, and it has nothing to do with being Caymanian or not being Caymanian, it was to do with when you're foreign qualified and being called here, you call under the umbrella of being called in a Commonwealth jurisdiction, that there was not a need to demonstrate that competency in Cayman Islands law in particular. Now, I know, Mr. Speaker, this is a practice that we've continued. We have this law from the 1969 law, and similar provisions exist in this law. And again, Mr. Speaker, not to say that there is, especially now if since we're moving the bar to 5 years PQE as opposed to what was a policy decision of 3 years PQE, clearly the practice of law is, the longer you practice, the more you are assumed to have developed some level of competency. I believe, Mr. Speaker, that in the next iteration of this law, should it pass here today, that the council, who will be responsible for education and training and determining who is fit and proper to be called, that serious consideration should be given to looking at how we include that kind of qualifying examination to demonstrate the at least basic minimum competency in Cayman Islands law. Because for me, it is about protecting the reputation and minimizing and mitigating the risk of qualifying people to practice Cayman Islands law without necessarily knowing that they have the competency on day one to do so and hold themselves out to be Cayman Islands lawyers. So again, Mr. Speaker, it is something that I felt very strongly about in 2017. My feelings still exist today because I think the primary purpose, as I said, of this bill is and should be to regulate the practice of Cayman Islands law, to ensure who and to determine who is fit and proper to hold themselves out to be Cayman Islands qualified lawyers, and therefore to protect the integrity of the profession as well as protect the reputational risk of the jurisdiction and otherwise, and that may be one way to mitigate that going forward. But as I said, Mr. Speaker, to quote the Chinese philosopher Lao Tzu, the journey of 1,000 miles begins with one step. And even though, Mr. Speaker, I am already talking about how I would like to see the law further enhanced and improved before we actually have a law that has been passed, it does not take away from the fact that we need to pass a new, modern piece of legislation such as that before this House today in order to take that first step to move us beyond the situation where we are today, where we know the legal framework to support this very important industry is woefully lacking. Mr. Speaker, with those few remarks, I would like to end my contribution by saying that I will be lending my support to the bill. I look forward to having the discussions during the committee stage or even prior to talk about the various recommendations that have come out from both the government bench as well as the opposition bench, because I believe, as I said, Mr. Speaker, this time around, I believe we're all approaching this with the view that needs to be taken, which is what is in the best interest of the jurisdiction and how can we get there in a way that we don't have a repeat of what happened last time, because ultimately the same people that we were on both sides arguing to protect and promote are no further ahead as a result of this House not finding a compromise position. So I really hope and I look forward to doing just that for the benefit of our people as a whole, of our budding and upcoming and seasoned attorneys alike, as well as all of those who work within the financial services industry and the broader industries that are impacted positively by the practice of Cayman Islands law, as I outlined earlier in my contribution. With that, I thank you, Mr. Speaker.
I want to call now on the Honorable Minister of Finance, who is going to speak at this time on Zoom. The Honorable Minister of Finance.
Thank you, Mr. Speaker, and thank you for giving me the opportunity this evening. Mr. Speaker, I rise to make a very short contribution to the debate on this historic bill, the Legal Services Bill 2020. Listening to the Premier recount the history of this bill and the time it has taken to get to this point, it clearly has to be a record in terms of time taken to develop a bill that is agreeable and has the support of the majority of attorneys in this country. But here we are this week debating this bill, and barring any upsets, this Honourable Parliament will likely approve it, bringing to an end a very long, tedious, and let's be honest, sometimes contentious process. The urgent need to have a modernised law to regulate and govern the legal services profession is one that cannot be overemphasized. That need was identified from as far back as the late 80s. Indeed, Mr. Speaker, I recall many a conversation during that time with my former father-in-law, Raymond Alberga QC, of the need then for a modern legislative framework regulating the legal profession. It has also been identified as a deficiency in our financial services legislative framework by several international peer reviews of the Cayman Islands over the years. So I know firsthand it's taken almost at least 30 years. But if there's one thing I've ever learned in life has taught me, it is this: nothing happens before its time. Mr. Speaker, the Legal Services Bill 2020 will replace the Legal Practitioners Law to regulate the practice of Cayman Islands law domestically and internationally. And the salient matters addressed in the bill, as have been elucidated on thus far throughout the debate, the establishment of the Cayman Islands Legal Services Board as a regulatory authority and to be assigned as a supervisory authority for the purposes of the proceeds of crime law. B, the regulation of the practice of Cayman Islands law. C, the requirement of 5 years post-qualification for a person other than a Caymanian or the holder of a residency and employment rights certificate to be admitted as an attorney at law by virtue of a foreign qualification. D, the practice of Cayman Islands law in other jurisdictions. And E, access to the legal profession and training and development of Caymanian attorneys at law. Mr. Speaker, I would pause and say at this point that I unequivocally support this bill that is before the House. I recognize that there are a number of amendments that are proposed at the committee stage, and I look forward to the healthy discussion and debate on those changes that will be proffered. Over the years, Mr. Speaker, I have participated in many meetings between government and SILPA and its predecessors, including the meetings with individual attorneys and non-attorneys, as we consulted with and received representations from all concerned. The aborted attempt in 2016 to get an earlier version of this bill approved by this Honorable House was a disappointment to me. But while it was a disappointment, one of the positive consequences of that is that it has given us the opportunity to make this bill better. 4 years is a long time, Mr. Speaker, and the environment we find ourselves in today, because of our efforts to find common ground for most of the contentious issues, is far different than it was back in 2016. Mr. Speaker, many of the naysayers would seek to turn back the clock on many of the positive developments that have taken place in the legal profession over the past several decades. However, to do so, I believe, in my opinion, would cause irreparable harm, not just to the legal profession, but to our financial services as a whole. Mr. Speaker, we cannot ignore the fact that in financial services, we are operating in a global arena and it requires a global presence. If we are to succeed and compete in this global arena, we must look forward, not backward, and we must seek to exploit every competitive advantage that we can identify for the Cayman Islands. Mr. Speaker, we cannot, I believe, restrict the ability of Cayman Islands law firms to practice Cayman Islands law in foreign countries, and yet open our doors and our borders to foreign firms to come in and practice Cayman Islands law. That to me is inherently unfair, and in my view, it does not makes the playing field very uneven and unlevel. In this industry, like many others, if you don't evolve with the rapidly changing environment very quickly, you are the loser. You will be left behind, and you will soon have a failed business. Mr. Speaker, government has gone to great lengths to ensure that there are reasonable and practical provisions for the education, training, including articles of clerkship, of Caymanians aspiring to become attorneys at law. This ensures that the profession will remain attractive to our citizens. And once this bill becomes law, what remains is for every person aspiring to become an attorney to step up and take advantage of all of the benefits that are made available to them, included by this law, including the ability to work in overseas offices of their employers. Mr. Speaker, one cannot ignore the many positive benefits that accrue to professionals who take advantage of these opportunities. Mr. Speaker, I am a strong proponent of Caymanian professionals, whether they be lawyers, accountants, bankers, whatever, having and taking advantage of opportunities to gain experience working in foreign countries. I can share with you now my own personal experience. Mr. Speaker, to my knowledge, in 1986, I was the first Caymanian professional accountant to accept a secondment to an overseas office of my employer, KPMG. In my 18 months in the United States, I worked in New York and Florida. The time overseas provided training and education opportunities that I could never have obtained in Cayman. It allowed me to establish relationships and network with diverse professionals, exposed me to a more diverse portfolio of clients and industries to work in, such as manufacturing and distribution, than I would have if Cayman was my only experience. I can say unequivocally this evening, it enhanced my promotion prospects, and indeed, it considerably shortened the time it took me to be admitted as a partner. 7 years versus the norm at that time of 10 to 12 years. Indeed, Mr. Speaker, I have 2 daughters who took advantage of similar opportunities, one for 3 years in San Francisco, the other for 1 year in Orlando. While they will tell you that they worked many, many long hours during that time, they will also readily acknowledge and tell you that it was absolutely the best experience in their professional careers to date. Mr. Speaker, the Honorable Premier has quite clearly articulated what the clauses of this bill seek to do, so there's no need for me to delve into it. In concluding my contribution to this bill, to the debate on this bill, I encourage all members to give it their full support and vote in the affirmative when the time comes. Mr. Speaker, the time is well past for the country to implement a modern legislative framework for the regulation of the legal profession. I believe this bill achieves that objective. I look forward to voting in the affirmative when the time comes, and thank you, Mr. Speaker.
I was minded to take a suspension till 6:20. Yes, 6:20. The House will suspend until 6:20.